Hello, everyone, and welcome to One Civil Law. I hope you're having a great day. And the President of the United States has issued an executive order regarding 47 USC 230, otherwise known as Communication Decency Act, Section 230, otherwise known as the backbone for the internet as you know it, /love it, /hate it. Basically, what it says in short, and we'll get into the details as needed, but basically, what it says in short is that if you are the platform, you are not responsible for what anyone publishes. You're responsible only for your own content. And of course, you can be both. You are both depending on what context you're in. So, is Facebook, Twitter, anyone else a platform or a publisher? The answer to that question is yes, because it depends what we're talking about. So they're responsible for their own content, everyone else is responsible for their own content, and so forth and so on. So we're going to read this executive order, see what it has to say, maybe talk a little bit about the law, talk about what might be possible, talk about some of the ideas that are going on here and what we might or might not be able to do. But first, we'll start with the executive order because that's what everyone wants to talk about. So let's talk about the executive order and see where that has to go. You always start talking before we can see, hear you. I usually try to wait a brief second before talking. I usually try to give it, it's hard to time exactly, but you hit go, and then I usually try to give it like a 2 count before I start. But maybe I should wait longer. Maybe I should wait like a 3 count. So maybe I should try to do that. At least when I watch it back, it looks right in when I watch it back. But maybe I should give it a longer count. But thank you for the notes so I can correct myself going forward. Anyways, let's get back to our subject matter at hand, this wonderful executive order. So this is what the President of the United States just signed. So we can start right away with, what is an executive order? Well, the executive order is law, but it's law that applies to the executive branch. So the President of the United States is giving a directive to other members of the executive branch. So it is law in so much as other members of the executive branch have to follow it. But it is not law in so much as it binds you or I. And of course, because the executive makes it up, they can modify it, change it, ignore it at any time that they want. So the President of the United States is not bound by his own executive orders, and he can modify them informally, formally, whatever. But they are binding on the executive, and to the extent the executive does something in response to that, then you would have an interest in that. So, for example, if the President of the United States issued an executive order that dealt with immigration policy, for example, and you were negatively impacted by that, you could get to what they were doing to the extent that what they were doing was not otherwise compliant with law. So what the executive does to you ultimately has to be compliant with law. So if they do something that's illegal, then you can get to them. If not, then not. But the executive order is law, but it's only law that applies to the executive. What happens to you is a whole different story. Anyways, with that out of the way, let's read this. By the authority vested in me as President by the Constitution and the laws of the United States of America is hereby ordered as follows. Policy 1. Section 1. Policy. Free speech is the bedrock of American democracy. It's not unusual in executive orders or legislation, that matter, to see policy statements. And it's also helpful in interpreting things later. So you can interpret things in light of various policy statements when you have. And the Communications Decency Act itself has policy statements as part of the law, just FYI. Anyways, free speech is the bedrock of American democracy. Our founding fathers protected the sacred right with the First Amendment to the Constitution. The freedoms to express and debate ideas is the foundation for all rights as a free people. Pretty good. Yeah, I think free speech is pretty paramount. I put it pretty much first among equals. So, in a country that has long cherished freedom of expression, we cannot allow a limited number of online platforms to handpick speech that Americans may have access and convey on the internet. Yeah, fair point. Fair point. And we may get into this later, but it does strike a little bit in terms of parallel with what we did in broadcast television with the fairness doctrine. But obviously there's some differences here, but we'll get into that later probably, depending on whether or not we need to. But at least we do have some precedent for the idea when there's a limited number of whatever that maybe the government has an interest in that. This practice is fundamentally un-American and anti-democratic. When large, powerful social media companies censor opinions with which they disagree, they exercise a dangerous power. They cease functioning as passive bulletin boards and ought to be viewed and treated as content creators. Fair enough. That's just a what ought to be. What is and what ought to be are two different things. So here's what ought to be. Okay, that's his opinion of what ought to be. Fine. Can't. It's just an opinion, right? It's a powerful opinion, but it's just an opinion. This is what should be. The growth of online platforms in recent years raises important questions about applying the ideals of the First Amendment to modern communications technology. Fair. Today, many Americans follow the news, stay in touch with families and friends, and share their views on current events through social media and other online platforms. As a result, these platforms function in many ways as the 21st equivalent of the public square. And we've seen case law that says that. In fact, I believe the United States Supreme Court themselves, in a decision, said roughly that same exact language. I believe the United States Supreme Court themselves said that the online platforms are the equivalent of the public square. So I believe that language comes from a U.S. Supreme Court opinion. Twitter, Facebook, Instagram, and YouTube wield immense, if not unprecedented, power to shape the interpretation of public events, to censor, delete, or disappear information, and to control what people see or do not see. Very, very fair point. Their ability to make things appear and disappear and like it never happened. So it becomes a little bit like the memory hole of 1984. We're not all the way in the memory hole of 1984 because it's not governmental action. But still, the amount of power these companies exercise is notable. The fact that you can disappear things that were once posted is concerning. We can revise history, right? As president, I've made clear my commitment to free and open debate on the internet. Such debate is just as important online as in our universities, our town halls, and in our homes. Okay. It is essential to sustaining democracy. I think there's a very fair point to be there. Free universities and town halls obviously have some public interest components, particularly when the universities are public. But either way, that these are places of free speech, and now we're moving into a new space, and we might need to deal with that. On-platform platforms are engaging in selective censorship that's harmful to our national discourse. They have the right under the current law, but we'll get into that to the extent that this is looking to change the law. Tens of thousands of Americans have reported, among other troubling behaviors, online platforms flagging content is inappropriate, even though it does not violate any standard terms of service. I've had this problem recently. I'm looking at you, Google Ads, who banned my account for no reason I can find, but whatever. I'm still getting paid by Super Chats, by the way. So if you'd like to contribute to Super Chats, I'm still getting that revenue. So I'm still part of the AdSense program. So if you want a Super Chat, I still get that money. This was more about me giving Google money. Google does not want me to give them money. Anyways. Tens of thousands of people have reported, among other troubling platforms, online platforms flagging content is inappropriate, even though it does not violate any state terms of service, making unannounced and unexpected changes to company policies that have the effect of disfavoring certain viewpoints, very fair, deleting contents in entire accounts with no warning, no rationale, no recourse. Again, I'm looking at you, Google. Twitter now selectively decides to place a warning label on certain tweets in a manner that clearly reflects political bias. And those labels would presumably be Twitter speaking, to the extent that they're being authorized by Twitter. So it would be Twitter speaking. So those labels might create some sort of liability for Twitter because they would be creating them. So they would no longer be they would be the publisher of those comments. And if they are selectively allowing particular third parties to do that, there might be an argument there. Because it's particularly if they are directly outsourcing it. So if Twitter themselves is doing it, then they're the publisher, or they're the publisher. Twitter themselves are doing it, the publisher. If they're hiring a third party to do it, they're the publisher, responding at superior liability. If they are just merely whitelisting particular people who are completely unaffiliated with them, then we get into a more interesting argument. But anyways. As has been reported, Twitter seems never to have placed such a label on another politician's tweet. Fair. As recently as last week, Representative Adam Schiff was continuing to mislead his followers by peddling the long-disproved Russian collusion hoax. Nice. And Twitter did not flag those tweets. Unsurprisingly, its officer in charge of so-called site integrity has flaunted his political bias in his own tweets. The political bias thing of the social media sites is really interesting. And one of these days, I need to find an article that explains to me how the social media sites change their politics. Because in the long, long ago, in the far, far away, when the social media companies, well, they weren't even called social media companies back then, but a long, long ago in the far, far away, when the internet was first created, the dominant political tenor of the groups that were part of the internet at that point was what is sometimes called techno-libertarian. That was the political thesis of the internet at large. And Silicon Valley was techno libertarian. So the philosophy of Silicon Valley in the long, long ago and the far, far away was basically Wild West mentality. Everyone does what they want. We allow anything. It's just whatever happens, happens. So it's a very, very libertarian philosophy. And for reasons that are not immediately apparent to me, and I'm sure there's an interesting reason, Silicon Valley, which went from this very libertarian shtick, went to this more progressive social justice leaning shtick, and has abandoned more libertarian principles for more control. So, not clear why exactly that happened. I mean, I could take a guess. If I had to take a guess, it would be that the people who started this thing originally were fighting the power. And so when they were out of power, because when the internet was brand new and people thought the internet might be a fad, because we're going way back in time, when the internet was brand new and people thought the internet might be a fad, these people were out of power. And so, of course, they wanted a lot of freedom from the constraints of the power structure that then existed. But now that they are the power, suddenly they want to keep the power that they have, so they switched. If I had to guess, that would be the reasoning, but that's just a guess. Anyways, back to this. At the same time, online platforms are invoking inconsistent, irrational, and groundless justifications to censor or otherwise restrict American speech here at home. Several online platforms are profiting from and promoting the aggression and disinformation spread by foreign governments like China. That gives the United States an independent interest, too. The freedom of speech protects us, not everyone, and certainly doesn't protect China. The freedom of speech, if you want a more technical answer of what the freedom of speech, who it protects those who are part of the polity, which is the citizens, green card holders, and other people who are closely associated therein. Visitors to the United States may or may not technically have First Amendment rights, although it doesn't actually come up that often. But in any case, the foreign governments don't have First Amendment rights under our Constitution. It's our Constitution. Thank you, Sumo, for joining. I appreciate you joining. And anyone else who wants to become a supporter, I would appreciate it as well. One United States company, for example, has created a search engine for the Communist Party that would have blacklisted searches for human rights, hid data unfavorable to the party, and track users determined appropriate for surveillance. Concerning. It has also established research partnerships in China that provide direct benefits to the Chinese military. Also concerning from a national security policy perspective. Other companies have accepted advertisements paid for by the Chinese government that spread false information about China's mass imprisonment of religious minorities, thereby abusing human rights. Very concerning. They've also amplified Chinese propaganda abroad, including by allowing Chinese government officials to use their platform to spread misinformation regarding the origins of COVID-19 and to undermine pro-democracy protests in Hong Kong. As a nation, we must foster and protect diverse viewpoints in today's digital communications environment where all Americans can and should have a voice. We must seek transparency and accountability for online platforms and encourage standards and tools to protect and preserve the integrity and openness of American discourse and freedom of expression. All generally good ideas, no major objections there. Section 2, protection against online censorship. It is the policy of the United States to foster clear ground rules, promoting free and open debate on the internet. Fair. The United States government has an interest in ensuring democracy, so there's some interest there. Prominent among the ground rules governing that debate is the immunity from liability created by Section 230C of the Communications Decency Act, now codified at 47 U.S.C. 230. It is the policy of the United States, incidentally, then this is really far afield. But it's just, I wouldn't go so far as to say it's coincidence, but it is notable that they have the same section number in the statute and in the CDA. So that doesn't always happen. And you'll see this, for example, in trademark law. For reasons that I don't understand, because I'm not a trademark lawyer. But for reasons I don't understand, Most trademark lawyers, when they cite the trademark law, they refer to it as the Lanham Act, and they cite the relevant paragraph number in the Lanham Act. That is despite the fact that it is codified in the United States Code at a different section number. So even though an attorney could cite the section number in the United States Code for reasons I don't understand because I'm not in that field, most trademark attorneys cite the section number in the Lanham Act even though it's a different paragraph number. It's just one of those weird things. So just notable, they have the same paragraph number, but that's not always the same, not always true. So if you're ever reading a trademark case and they cite Lanham Act section whatever, it doesn't correspond to the same paragraph number in the U.S. Code because trademark lawyers, I guess. It is the policy of the United States that the scope of immunity should be clarified. The immunity should not extend beyond the text and purpose to provide for protection for those who purport to provide a user for free and open speech, but in reality use their power over a vital means of communication to engage in deceptive or pretextual actions, stifling free and open debate by censoring certain viewpoints. I'm not sure they're exactly pretextual. They're more textual because something is a pretext when you're hiding the ball. But most of the time, the social media companies aren't hiding the ball. So it's not really pretextual so much as it is textual. But either way. Section 230 was designed to address early court decisions holding that. Yeah, this is going back into the before land, before 230. Yeah. Section 230 was designed to address early court decisions holding that if an online platform restricted access to some content posted by others, it would therefore become a publisher of all the content posted on its site for the purposes of tort such as defamation. Yeah, so in the long ago, before 230, the standard rule, at least adopted by the courts, was that if they allowed everything, then they wouldn't be a publisher. But if the internet companies were engaged in any kind of censorship by blocking certain posts or whatever, they'd be liable for anything that they didn't have left. The idea essentially there is that they became a republisher. So they became a publisher of the content by moderating it. And so if you didn't moderate anything, then the rule before was you weren't a publisher. You're just allowing everything through. You're just like a telephone wire. You know, the AT&T, Verizon et al. Do not restrict content as it goes through the pipe. It's just everything goes through the pipe one way for telephones at least, right? They don't restrict it. It goes one way through the pipe no matter what the content is. So they don't do any restriction. So the early court decisions were essentially analogizing it like that. They were saying, well, if you are just letting everything through, then you're not a republisher. You are just transmitting the content. So you're not publishing the content. You're merely transmitting the content. But if you engage in moderation, then you have, by implication, affirmed everything you haven't moderated, and so you are a republisher. And in classic tort law, a person who republishes is also liable to the same as though the person who made the underlying content. So that was the decision before, is you didn't do any moderation, you were liable proof. If you moderated, you were liable. And the Congress went and looked at this and this doesn't make any sense. So that's what they were trying to change. As section title of 230 makes clear, the provision provides limited liability protection to provider of an interactive computer service, such as an online platform that engages in Good Samaritan blocking of harmful content. In particular, Congress sought to provide protections for online platforms that attempted to protect minors from harmful content, and intended to ensure that such providers would not be discouraged from taking down harmful material. The provision was also intended to further express the vision of Congress that the internet is a form of diversity in public discourse, citing Section A3, because as I mentioned, it's not unusual for statutes to have policy parts so that are not operative, but they just provide policy. So Section A is not operative. It doesn't do anything except say, well, this is the policy of the statute and here's why it exists. So it expresses senses of Congress. Here's why we think this is good. So subsection A is not operative. It's just, this is why we think it's good. The limitation, and they said they want a forum for true diversity of political discourse. That was one of their purposes. The limited protections provided by the statute should be construed with these purposes in mind. Fair enough, because see, this is where as an originalist, you would use purpose. Why? Because Congress actually passed it as part of the law. So to an originalist, yes, you would use this because Congress actually passed it. It's not part of a floor speech. It's not part of a committee note. It's part of the law. It's part of the law. So in interpreting anything that's ambiguous in a statute, yes, an originalist would absolutely look to these policy statements because although they are not operative, they are nevertheless law. They may not be operative law, but they are law. So if there's an ambiguity, you would look to the things that Congress also passed to say, well, here's how we want to interpret it. No problem. Now, you can't use those things to interpret it to get past an ambiguity that doesn't exist. So you can't use the purposes to say, well, a thing that's clear means something else. You can't do that. But in the event of an ambiguity, you can rely on the purposes, and an originalist will be perfectly happy with you. No problem. It's also something Congress passed. It is also something the president signed. It is also law. It's something I can rely on. So in the event of ambiguity, I can refer to that. Very good stuff. Thank you, Douglas McCullum. I appreciate your support. Very good. So in particular, this subparagraph expressly addresses protections from civil liability and specifies that in an interactive computer service, provider may not be liable on account of its decision in good faith to restrict access to content that considers it to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. Yeah, so it has to be in good faith, whatever that means. And I was looking a little bit into what that means, as best as I could determine from the case law. So it appears to be fairly open. There have been a few cases where it was not held to be in good faith. One example was where the provider was censoring it because the person in question had not paid an amount of money. So it was like an ISP, and they hadn't paid money that they were owed. And so as a result of that, that's why they took it out. So that was not held to be in good faith because it wasn't for any of those reasons that were listed. It was because of a contract dispute. So that was held not to be in good faith. And another one that I sort of was reading in the case law seems to suggest that if you're not applying your own rules evenly, that might be good faith, but then you also have to keep in mind that you can change your rules. So there's some problems there. So good faith is not doing as much as you want because all the standards are subjective. It's good faith, but it has to be you who consider it to be these things. And you can obviously change your mind, just like you or I can. What is lewd? What is lewd to you? Well, whatever it is right this second, it may not necessarily be what you thought a year ago or may think a year from now. So you can change your mind, and these companies can change their mind. So the good faith thing, it seems to be fairly narrow in what it is doing, at least in terms of the case law. I was able to research and looking this up. It is a policy of the United States to ensure that, to the maximum extent permissible by law, this provision is not distorted to provide liability protection for online platforms that, far from engaging in good faith to remove objectionable content, say they're going to try to. I knew they would do this before I even read it. I want to make clear that I have not read this prior to coming here. And although I just discussed good faith, I actually hadn't read that far ahead, but I knew they were going to pin it on good faith because I read the statute. I reread the statute before doing this, but I didn't reread the EO. So I was thinking to myself, okay, if I were looking for a way to do a regulation within the statute, what would I do? So if I were the White House counsel and I was looking for a way to do this, what would I do? And the best language I found was the good faith. And that's why I went down the rabbit hole of starting to do case law to try to figure out if I could get away with that. Because I'm like, oh, this is the best language that has given me a hook for any regulations I can do. So I feel validated that the White House counsel also thought of this as an idea. So they thought of the same idea I did. Let's see if they better develop it than I did, because I've done about 20 minutes of research, and presumably they did a lot more. So maybe they came up with a more thorough answer, but at least we came up with the same idea. Oh, we're going to use this as a linchpin. Excellent. So far from acting in good faith to remove the objectionable content, instead engaging in deceptive or pretextual actions. Again, they're not so much pretextual as textual because they're not hiding the ball. Pretext is where pretext would be, for example, if an employer fires someone because of race, but what they actually say is, I'm firing you because of your work performance, but that's not actually the reason. The work performance is a pretext. The actual reason is the pretext is you're not doing your job. The text is race. So the publishers that we're talking about most of the time are not saying, I'm doing it because of one reason. Most of the time, they seem to be pretty honest. So it's not so much pretextual as textual, because they're just telling you why they're doing it. We believe in certain things, and we believe in social justice, and you're not one of the cool kids, so we're censoring you. That is not pretext. That's just text. Minor disagreement, but yeah. So often contrary to standard terms of service. So yeah, you might be able to squeeze something out of the standard terms of service, but again, you have this problem of the standards are ultimately subjective, and you can change your mind. So you might be able to squeeze something into that good faith argument in an idea of not equally applying it at any time, but it's going to be tough because you can change your mind. So it's like, well, it's not that I'm being uneven. I've just changed my mind as to what those things are. And so given the new standard that I've just adopted, now I'm going to do that, and now it's good faith. So you have a problem there, but you might be able to squeeze something in there if you look at it really hard. Good luck with that plan, though. Good luck with that plan. I'm not saying it's impossible. I'm just, as an attorney, thinking it's going to be really, really, really hard to do what I'm trying to do, because the other language is so subjective in nature that trying to do what I'm trying to do through good faith is going to be a real problem. I'm just thinking ahead to how a court would interpret it. Because the other stuff is so subjective, trying to squeeze some sort of essentially objective rationale into good faith is going to be difficult. I'm not saying it's impossible. I'm just saying it's really difficult. So I'm looking ahead. Section 230 was not intended to allow companies to grow into titans, controlling vital avenues for a national discourse under the guise of promoting open forum for debate, and then provide those behemoths blanket immunity when they use their power to censor content and stifle viewpoints they dislike. One could get into discussions about what the law was or was not intended to do. And I think in some part it was probably intended by at least some people to allow certain things to be censored, because the Communications Decency Act, Section 230, right, was one part of a much larger bill, the Communications Decency Act. It had other sections other than 230. Pretty much all the other sections have been ruled unconstitutional by a court, and so 230 is the only thing left. But the fundamental point of the Communications Decency Act, not Section 230, mind you, the fundamental point of the Communications Decency Act as a whole was to regulate and restrict certain content of more adult natures. That was the fundamental purpose of the Communications Decency Act. So whether 230 on its own terms was intended to restrict viewpoints, the Communications Decency Act as a whole was somewhat notable for attempting to restrict content based on particular content that the people writing it didn't like. And because it raised obvious First Amendment problems, pretty much all that other stuff has been rendered moot. But yeah, 230 by its own terms may not be talking about particular viewpoints we don't like, but the rest of the Communications Decency Act, a little bit, yes. It's a little bit, yeah. When an interactive computer service provider removes or restricts access to content and its actions do not meet the criteria of subsection C2A, is engaged in editorial content. Well, what is C2A? Because I know I have it up here somewhere. Well, we can just flip in between. Like, so what is C2A? B, C2A. Okay, so yeah, that we all saw that section. So this is what we want to try to squeeze into. Any action voluntarily taken in good faith, and we're going to try to make good faith do a lot of weightlifting. I use that phrase sometimes to express an idea where we're trying to make a word or things do a lot of stuff. And sometimes you can do that. For example, in the Constitution, when you talk about the freedom of speech, well, what is that? Well, that's doing a lot of weightlifting, because it's basically incorporating by reference all the case law of all the stuff that happened before then. So when you try to figure out what the freedom of speech is, it's talking about the freedom. So those 5 words, the freedom of speech, that's 4 words, the freedom of speech. The freedom of speech is doing a lot of weightlifting. And so you do the same thing in like other contexts. So when I say it's doing a lot of weightlifting, it's like we're trying to make these 2 words, good faith, do a lot of stuff. It's going to be problematic. So any action taken in good faith to restrict access to or availability of material that the provider or user considers, which makes it subjective in your own head. That's the problem. So even if I can make good faith somehow objective, the thing I'm doing is subjective, that you personally consider to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So you're gonna have you're gonna try to put a lot of weight into this phrase good faith. You're gonna have trouble with a lot of this rest of this language. But yes, to the extent that you're not doing this, you would be outside the protections. Unfortunately, the protections are pretty wide, so you're gonna have a problem. So when they remove content and they do not meet this criteria of this paragraph, it's engaged in editorial content. I don't know if I describe it as editorial in nature, but it's outside the protections of the statute. So either way, it doesn't matter. It's the policy of the United States that such a provider should properly lose the limited liability shield of that paragraph and be exposed to liability like any other traditional editor and publisher that's not an online provider. I mean, slightly fair point. The New York Times, by contrast, the New York Times, the paper, not New York Times, the online site, but New York Times, the paper, is responsible for anything it puts in the paper. Online site, maybe a different analysis. But no matter who wrote it, because they don't have these protections, they're not an online thing. And for that matter, most, TV wouldn't be, they're not covered by this. So only internet providers are covered by this in terms of republication doctrine. So no matter who prints it, if the New York Times reprints it, they might have a problem on their hands. And here, that's a different rule for these people. So maybe to the extent they're editorializing or they're making edits, we should say, well, they're adopting that. They're just not merely transit. So letters to the editor, they might be, for example, letters to the editor. I don't know the case law that well, but I'll just assume letters to the editor, for example, are just reprinted in full usually. So they're probably not edited. So they probably just qualify as transmitted rather than republished. But I don't know the case law that well, nor does it really matter right now. To advance the policies described in subsection A, all executive departments and agencies should ensure the application of the law properly reflects the narrow purpose of the section and take all appropriate actions in this regard. Tough. In addition, within 60 days of the order, the Secretary of Commerce, in consultation with the Attorney General and acting through the National Telecommunications and Information Administration, shall file a petition for rulemaking with the FCC, recording that the FCC expeditiously proposed regulations to qualify. I'm not sure how the FCC, under its current rules, can do that. Because the FCC, under its current rules, remember, because there's a whole Category 1, Category 2 thing, with whether or not the FCC was regulating it and whether or not they were, what's the term for that? Common carriers. Remember that whole discussion and that whole debate, and how the Obama administration had one thing and then the Trump administration changed it back. So if we were still under the old rule where the internet were common carriers, then yeah, the FCC would have jurisdiction under the common carrier things. Now, common carrier comes with a whole boat of other things. For example, fair and equitable treatment. So maybe it is desirable, but that was not what the FCC wanted to do. The FCC went under Section 2, or they went under Section 2, because they've been under both. So they had it under Section 1, which is common carrier, and then they had it under Section 2, which allows the states to basically do what they want. And we've also seen the negative implications of that, because some states have adopted common carrier rules, and the FCC actually went to court over it, and the FCC actually lost. Because they were under 2, they didn't have the authority anymore, because they had said, well, this isn't our ball. This is the state's ball. And the court said, okay, it's not your ball, it's the state's ball. And so you can't object if a state puts in common carrier rules. And the FCC said, that's not fair. And it's like, well, it's your choice. Do you want to regulate this or not? Pick one. You have the right to classify them under Rule 1 if you want. There's case law that says that. I think the U.S. Supreme Court actually upheld it in a decision. So the U.S. Supreme Court says, yeah, you can regulate under number 1 if you want. Now, that comes with a whole host of things, good and bad. You can regulate it, but it means there's a neutrality thing. So you have to have neutrality, which they didn't want to do. They wanted more flexibility, so they put under 2. So I'm not sure what the FCC can do now, because the current regulations don't allow for the FCC to do anything, because they're regulated under Title 2, not Title 1. I suppose the FCC could re-regulate them under Title I, and then the FCC would have regulatory authority because it'd be regulated under Title I. But the administration doesn't want to do that because then that comes with a whole host of things that apply to common carriers. Common carriers have to have neutrality, and they can't meter content, and they can't put in fast lanes and all that stuff that the administration might want them to do. So I'm not sure what authority the FCC has. I don't think they have any. So they kind of regulated themselves out of that one because they put it under Title II by their own regulations. So the FCC can't really do it. I don't know what the FCC is going to do. They can't do anything. Good luck. Good luck, FCC. I'm not rooting for you, but good luck because you've got a problem there. Good luck on figuring that one out. Which one do you want? Do you want Title I or Title II? Your pick. Do you want Title II so that people can put up fast lanes, or do you want Title I so you can regulate it, but they can't because they're common carriers? Let me know what you want to do. That'll be good luck. This is literally the meme with the guy over the two red buttons. This is literally the meme with the guy over the two red buttons sweating it out. Do I push one for Title I so that I can regulate it? But that comes with a whole bunch of regulations by law that I can't get past as towards a common carrier. So I press button 1 so that I have control, but I have to treat them as a common carrier. Or do I press button 2 so I don't have to treat them as a common carrier so they can do what they want, but it also means I can't regulate them and the states are free to regulate them? Which one of these buttons do you want, FCC? Good luck. Good luck. So we want the FCC to propose regulations to clarify. Good luck with that plan. The interaction between subparagraphs C1 and C2 of Section 230 in particular clarify and determine the circumstances under which a provider of an interactive computer service that restricts access to content in a manner not specifically provided by the paragraph may also not be able to claim protection under whatever, which merely states a provider shall not be treated as a publisher or speaker for making third-party content available and does not address the provider's responsibility for its own editorial decisions. Good luck, FCC, trying to figure out how you have regulatory authority. Because you, by your own regulatory authority, removed your own regulatory authority. Genius work. Good job. By your own regulations, you've removed your authority to regulate. Great work. You could change your mind and bring it back under Title I. Let me know if you want to go that way. That'd be good. That'd be really entertaining. The conditions under which actions restrict access to or availability of materials not taken in good faith within the meaning of that, particularly when actions taken in good faith, if they are deceptive, pretextual, again, I'm not sure they're pretextual, but or inconsistent with the provider's times of purpose, taken after failing to provide adequate notice, reasoned explanation, or meaningful opportunity to be heard, and any other proposed regulations that the whatever group concludes may be appropriate to advance the policy described. Good luck with that plan. Good luck on the FCC plan. I'm not sure what the FCC can do to help you because you kind of hurt yourself on that one. Section 3, protecting federal tax-paying dollars from financing online platforms that restrict speech. Okay. The head of each executive department and agency shall review its agency's federal spending on advertising and marketing paid to online platforms. Okay. Such review shall include the amount of money spent, the online platforms that receive the dollars, and statutory authorities available to restrict the recipients of advertising dollars. Fair enough. The spending power is the big cudgel. If Congress has said money has to be spent in a particular way, they have to spend money in a particular way. And we have seen that in, for example, the sanctuary cities cases. And there is some disagreement on the courts of appeal. But the courts of appeal, some of them at least, have said generally, and I think it's probably correct, this doesn't fit my political leanings, but on a statutory level, on a legal level, I think it's correct. And some courts have said no, but I think the better legal answer is that because the way the statutes are written in those cases requires the executive to spend money in particular ways. And so what the administration was trying to do was saying, well, we won't give you money unless you do certain things in terms of telling us who immigrants are, in terms of not being sanctuary cities. And the city has said, well, that's not fair, because it's not part of the rules of the thing that Congress sent out. And I think the cities had the better end of that argument. I don't think there should be sanctuary cities, but that's a whole other set of issues. Legally, I don't think the president can just add restrictions anytime he wants. Now, to the extent that they have discretion in spending, then yes. So I would presume in this context, the statutes are written in such a way that probably they don't even say anything about advertising at all. Probably it doesn't even say anything. And if it does, it probably says something like, yes, you can do advertising. But it doesn't say anything more specific than that. So presumably, then the executive could choose to spend money or not, depending on whether or not they approve of those platforms or not. So I would assume that they have the ability to do this, because I'm assuming those statutes are not written that tightly. It probably doesn't say you must give $30 million to Facebook for advertising. It's probably not that specific. So it probably leaves it open. So yes, you probably can do this. And government money is lots of money, so it may be effective in some degree. So the head of each executive department and agency shall review its agency's federal spending on advertising and marketing paid to online platforms. The government likes to promote itself too, so they advertise as well. Such review shall include the amount of money spent on the online platforms that receive and statutory authorities available to restrict. You probably can do that. Within 30 days of this order, good, that's tight. Within 30 days of this order, the head of each agency shall report its findings to the Office of Management and Budget. The Department of Justice shall review viewpoint-based speech restrictions by each online platform identified in the report of the section and assess whether any online platforms are problematic vehicles for government speech due to viewpoint discrimination. It's the government restricting its own speech. So here they're probably in the clear. The government has the right of freedom of speech too, and they have a right of freedom to spend their money in support of that speech. Remember, money is not speech. It facilitates speech, but it's also a big interest. So yes, the government can control its own speech, and it can control where it spreads that speech, and it can control the money it spends. So I think this is probably legal. And, the government spends a lot of money on these things. So we're talking about big numbers. Now, whether those numbers are big enough to get anyone's attention in social media, who knows? Whether or not Twitter and all those other companies can survive the advertising fallout, who knows? I don't know what the government's budget is for these things, and I don't know how much the revenue is. So does Twitter, Facebook at all care? I don't know whether or not they care, but it's probably legal. It's the policy of the United States that large online platforms such as Twitter and Facebook are critical means of promoting the free flow of speech and ideas today, and they should not restrict protected speech. That's a policy statement, sure. The Supreme Court has noted social media sites as the modern public square can provide perhaps the most meaningful and powerful mechanisms available to a private citizen to make his voice heard. Communication through these channels have become important for meaningful participation in American democracy, including the right to petition leaders. Yeah, I agree with that. I will also remind everyone on the stream, because last time I didn't remind everyone. If you've not already done so, if you'd give me a like, I'd appreciate it if you do so. And for those of you who are so inclined, if you'd like to give me a super chat, that would be very helpful. I always appreciate your financial support. And I appreciate the 107 of you who are here. It's very, very awesome. Thank you. These sites include an important forum for the public to engage in free speech and debate. In May 2019, the White House launched a tech bias reporting tool to allow Americans to report incidents of online censorship. In just a week, the White House received 16,000 complaints of online platforms censoring or otherwise taking actions. The White House will submit these complaints to the Department of Justice and Federal Trade Commission. You might be able to get somewhere with the FTC if you can show deceptive. You might be able to get somewhere with the FTC if you show deceptive advertising or deceptive marketing. So you might be able to get you have more hope with the FTC. Not a lot more hope, but you have more hope. So to the extent, because the FTC's interest is in regulating commercial speech to the extent it has to be honest. So commercial speech is typically reviewed as intermediate scrutiny. So it's not strict scrutiny, it's intermediate. And one of the things that you can typically do as a government is ensure that commercial speech is true. Now, we can get into things like puffery. So you can exaggerate in a way that's so clear that no one reasonably could believe it. But so the classic example is a sign that says world's best cup of coffee. No one is going to believe that statement is literally true, particularly if it's just hanging in an average diner. I'm looking at you movie Elf. So that would be puffery. So short of that, though, it has to be honest. So you might be able to get somewhere with the FTC to the extent that Twitter, Facebook, in their general marketing, in their general whatever, is holding themselves as an open, free platform, blah, 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 and is only in the buried terms of service saying, by the way, all this stuff, you might be able to get somewhere with the FTC on deceptive marketing. Now, I think that's going to be tough. I think the FTC is going to have a tough time, but you might be able to try to do something. $2 from Q Squared for the super chat. As always, Q Squared is super appreciated. My apology, I'm not as active tonight. I'm listening, though. That's cool. We always appreciate people who are listening, and the chat is doing stuff. So there seems to be a nice chat going on. So we received a whole bunch of stuff. All right. The FTC shall consider taking action as appropriate and consistent with the applicable law to prohibit unfair or deceptive acts or practices in or affecting commerce. Yeah, you can't be deceptive or unfair. So the FTC might be able to get somewhere. You're going to have a tough time. I would not want to be the FTC. If you ask me which side would I want to be on in this legal battle, I'd rather be on the social media side. The FTC is going to have a tough time. It's not impossible, but it's going to be tough. The FTC might also be able to put out some regulations. The FCC won't. But the FTC might be able to do something in regulatory authority dealing with these issues in terms of marketing. So they might be able to put out some regulations that would prevent Twitter and Facebook at all from holding themselves out to be one thing and only in their terms of service buried deep somewhere says something else. The FTC might be able to get away with regulations. They have authority. The FCC not so much. Everyone, if they do, everyone's going to fight them to death, but they might be able to get somewhere with that. Such unfair and deceptive practices may include practices by entities covered in the Section 230 that restrict speech in such a way as those do not align with the entity's public representations about those practices. You know, it's always validating to me when I say something and the case I'm reading, whatever that is, says the same thing 2 sentences later. That's the second time that's happened now. I just said something. Here's how you would do that. And then at the end of the executive order, the president says, here's how you do it. I'm like, I feel very validated when I do that. It's very, very validating to me when I'm reading something. I'm like, okay, given that, here's how you would do it. Here's how that statute would apply. And then you get to the end of the paragraph and it says, here's how to do it. That's the second time tonight that I got it without reading it first. The first time was when I was like, oh, the good faith is your best basis. And then the EEO said good faith. And then, oh, here's how the FTC would do it. And here's how the FTC would do it. I mean, it means I know things. I'm very happy. It's always nice when you get immediately reaffirmed. It's that instant validation is nice. For large online platforms that are vast areas for public debate, including the social media platform Twitter, the FTC shall also, consistent with its legal authority, consider whether complaints allege violations of the law that implicate the policies of this order. The FTC shall consider developing a report describing such complaints and make the report publicly available, consistent with law. I don't see any problem with the FTC producing a report. The FTC can make a report. Here's all the ways that social media companies are bad, disingenuous, hypocritical, or whatever. So yeah, the FTC can write a report. Here's all the bad things they're doing. Here's all the things they could be doing. And then that report could presumably become a basis for either action by the FTC, maybe some antitrust action. So that report could be used as, or maybe even some private action, potentially, depending on what they discover. So there might be some ideas there. Section 5, State Review of Unfair or Deceptive Practices and Anti-Discrimination Law. The Attorney General shall establish a working group regarding the potential enforcement of state statutes that prohibit online platforms from engaging in unfair and deceptive practices. Interesting idea. Interesting idea. There's going to be some problems potentially with some supremacy clause stuff, because I think to a large degree there might be preemption of the field, but there might be something left for the states to do here. There's going to be a problem. It's not clear what immediate state authority they have, because the FCC gave up the authority, though, by regulating them under Title II. They have more authority than they would, so that's a plus. So there might be something here for the states to do, but it's a little bit. So yeah, that might be something to develop. What can the states do? The working group shall also develop model legislation for consideration by the legislature where existing statutes do not protect Americans. Fair enough. Model statutes are always good. A lot of things come by model statutes, and sure, the Attorney General can write a model statute just like anyone else. Whether or not it's legal, who knows? But if it's the Attorney General writing it, hopefully. The working group shall invite states' attorneys general for discussion and consultation as appropriate and consistent with the applicable law. Complaints described in Section 4 of this order will be shared with the working group consistent with applicable law. The working group shall also consider publicly available information regarding the following: increased scrutiny of users based on the other users they choose to follow or interactions with other users. Okay, yeah. So we want to make sure that, yeah. So we want to be concerned about not necessarily the user's speech as such, but more about their affiliations. So that'd be more. It's not strictly probably freedom of speech. It's more about freedom of association, but like who you're following and who maybe you're retweeting, something like that. So there's an idea there for freedom of association. Algorithms to suppress content or users based on indications of political alignment or viewpoint. Differential policies allowing for, yeah, particularly, and this is where you might be able to get somewhere, particularly where that is not made clear by their own rules. So particularly where it's not made clear by their own terms of service, you might be able to get somewhere, because then you might be able to argue not good faith. So if you might be able to get somewhere there, but it's going to be a tough road. It's going to be tough. But you might be able to get somewhere on political alignment or viewpoint to the extent that the rules do not otherwise state. And then the FTC might be able to get somewhere with inconsistencies with their general things. So there's some ideas here that are possible, but they're going to be tough. The reason it's tough, by the way, is because, as I mentioned before, the language is so subjective. I'm trying to make good faith do so much stuff when the rest of the language is so subjective. So I'm trying as an attorney, I'm thinking both as though I were the executive agency and also as though I were a court. So I'm thinking in both contexts at the same time. What could I, as an attorney, if I were employed by the FTC or FCC or whatever, what could I as an attorney put in a regulation that I, as a judge, interpreting those regulations is going to work? So I'm putting myself in both contexts at the same time, trying to figure out what can I make work. And given my own interpretations of the statute, how can I write a regulation that's going to work with my own interpretation of the statute? It's going to be tough. It's going to be tough to do both at the same time. But, that's fine. $20 from Willie Czar. Thank you very much for the super chat. Is Trump saying his free speech is curtailed? It's at least being modified by Twitter's speech, because my understanding is these tags are coming from Twitter. So it's being modified and commented on. So I don't know if curtailed is quite the right word, but it's being treated differentially because his content is being treated in a way that, as far as I'm aware, is different from everyone else. So they are being not even in a way that might be a problem. But yeah, seems like he's just being insulted and he doesn't like it. Maybe. I think there's some legitimate problems. I think the conservatives have a legitimate point. That conservative thought, and for that matter, a lot of left-leaning thought these days, because the political spectrum is such the way it is. So not even right-leaning thought, a lot of left-leaning thought is being censored because the social media platforms have gone so off the bend left-wing, or at least so it seems to me, that it's becoming a problem. So the conservatives are concerned about this, that they are not being treated fairly in the speech, and they would very much like to spread their message. And being both right wing and whatever, it's like I would also like to spread my message. I like to express my thoughts. I'd like to not be shadow banned by everyone in existence. That'd be great. Twitter isn't the government, so they can't curtail when he can't. So can't they curtail where he can? Yes, probably broadly yes. Twitter is a private platform, but like all good things, it comes with restrictions. And the most obvious restriction, I guess we might as well talk about it now for lack of a better time. The most obvious thing that comes to mind is when the U.S. government was regulating broadcast media under the Fairness Doctrine. So the Fairness Doctrine was a thing the FCC had for broadcast television from like the 1960s until 1981. And the reason that they had it was because at the time TV existed as essentially 3 channels. Because we're talking about a time before cable. We're talking about before satellite television. We're talking about a time when television was broadcast on the air. And the problem is that there's only so much spectrum to give around. There's only so much spectrum. And the spectrum has to be used for other things other than just television. It has to be used for radio. It has to be used for ham radio. It has to be used for all kinds of stuff, for microwaves, for all kinds of stuff, right? So there's all kinds of stuff that's using the spectrum. So there's a limited spectrum. And so the FCC regulated it by saying it has to be fair. The Fairness Doctrine basically said, in short, that if you have one person from a political I'll make it just the broadest way. This is not what it was limited to, but this is the most obvious application of it. If you had someone who was there to speak for one political party, like officially, you had to invite someone else from the other political party to speak for equal time. So that was the fairness doctrine in short. It was broader than that, but that's the fairness way. And it was banned in 81. And the idea was that so much stuff is happening in a channel that's limited that the U.S. government has the ability to insist on this. And as I pointed out, the U.S. Supreme Court upheld that. Now, it's not clear they would uphold it here, because the rationales for the FCC's regulation for as it relates to TV, or for that matter radio, or for that matter the entire electromagnetic spectrum is different, because the entire electromagnetic spectrum is limited. There's only so much of it that's suitable for any purpose, and some bands are better for other purposes than others, and there's only so much to allocate, and there's a public interest there in regulating the airways because we only have so much of it. So that was sort of the justification for the fairness doctrine. So it is applicable. So the fairness doctrine is applicable to the current situation in so much as, like ABC, CBS, NBC before, Twitter and Facebook and whomever else you want to throw into this sentence, maybe YouTube, Twitter, Facebook, and YouTube have gained so much share that they're so dominant as compared to anything else that maybe there's a rationale to regulate them. The way it's different is that there is no limitation on spectrum. So you can have infinite number of companies competing in the space. So the rationales are not quite parallel, because the FCC's ability to regulate was based on a limited spectrum that doesn't exist here. There's no limitations. I suppose there's a limitation in so much there's only so many IP addresses, but because of IP6, we don't even have that. Anyways, so the rationales are a little bit different. But so it's not clear that you could apply the fairness doctrine in this context. You could try, but obviously you'd have a massive fight on your hand. The supporting proposition for the fairness doctrine would be like, it's so constrained that it is so tight, but the argument against is the rationale isn't there. So how does that go into court? Who knows? So yeah. Reliance on third-party entities, including contractors, media organizations, individuals with an indicia of bias to review content. Fair enough. Acts that limit the ability of users with particular viewpoints to earn money on the platform compared with other users. Okay. Legislation. The Attorney General shall develop proposed federal legislation that will be useful for promotion of policy. That's cool. Let's get some. We can always change the law. And then we're going to get into a fight about that, but we'll talk about that in just a second because I'm almost at the end of this thing. No, general provisions. Nothing in this order shall be construed or to impair or otherwise affect the authority granted by law to an executive department or agency or head thereof. So if you had authority somewhere else, we're not trying to constrain it. You still have that authority. We're just trying to direct you. The functions of the Director of Office of Management Budget related to budget. This order shall be implied consistent with applicable law and subject to availability of appropriations. And this order is not intended to and does not create any right, benefit, substantive, or procedural applicable at law. So that sentence there at the end is basically saying in so many words that you as a private individual cannot sue over this, because this is just a directive to the agencies. This isn't creating any right to you. Now, ultimately, what the executive branch does ultimately might give you some rights, but you can't sue over this. You can't sue over this. You can sue over what eventually happens. So to the extent that regulations get published, you might be able to sue over that, to the extent that, all that stuff. All right. So let's talk a little bit about what kind of stuff might be legal and what might not be legal in terms of legislation. So what can Congress do? That's always a good question. So what can Congress do? And incidentally, as I've mentioned many times, I'm not a fan of the administrative state. I'm not a fan of Chevron. I'm not a fan of Auer. I'm not a fan of Bad X. I prefer things to be done with legislation. So, in terms of the law, what they can do, Chevron. So, but in terms of what they should be able to do, yeah, I'm not a fan. I like the old rule. I like the old Skidmore rule. Make Skidmore great again. I'm going to get some merch at some point that says make Skidmore great again. That'd be good. Anyways, so what can Congress do? All right. The first thing that we should establish is that CDA 230 is a thing Congress created. It is a thing that Congress created, and Congress could uncreate it. It is an immunity given by Congress exercising their authority under the Interstate Commerce Clause, which I have my own problems with. See Wickard v. Filburn, but again, not material to our present discussion. It regulates interstate commerce, and this is stuff that's traveling across state lines and involves money and commerce, and everything's interstate commerce anyway. As we remember from our prior discussions, non-commerce that occurs wholly within a state is interstate commerce. Don't ask me, ask the U.S. Supreme Court. But yes, Anyways, non-commerce that occurs wholly within one state is somehow interstate commerce. Don't ask questions. You'll just become more confused. Anyways, so what can Congress do here? Well, Congress could strike it down. I mean, Congress could just remove it completely and go back to the old times. That would be entertaining, I'm sure. But they don't want to do that. So can Congress restrict the immunity, or can they condition the immunity based on the provider being viewpoint neutral? Would be the question. Now, you would have to define viewpoint neutral in a way that makes it clear, but that can be very reasonably done because we have case law on what viewpoint is. We have lots of Supreme Court cases on viewpoint. So writing a regulation that makes things clear enough, or writing a statute for that matter, writing a statute that makes it clear enough, or a regulation that makes it clear enough what we mean by a place that a company has to be viewpoint neutral, I don't think is that hard. That's pretty easy. The thing is, can Congress do that? And the answer to that question is I don't know what the answer to that question is. And because I don't know what level of review is required for that. Because it's a very weird thing logically. If Congress were to say that you only get Section 230 protection if you had a particular viewpoint. So if they said, for example, if the law said you only have 230 viewpoint if you say America is good and you don't say America is bad, that's not legal. Why is it not legal? Because the government is requiring you to have a particular viewpoint. And that's a constitutional no-no. You can't do that. That's either strict scrutiny or just per se unconstitutional, depending on which case you want to refer to. So it might be either very difficult for the government to do or just impossible for the government to do, depending on which case you want to rely on. So the government cannot condition something on you having a particular viewpoint like that. They can't do that. So the question is, can they require you to be viewpoint neutral? Is that the same thing as having a particular viewpoint? And I don't know the answer to that question. Because if it were the government acting in terms of its own speech, then viewpoint neutral speech is typically intermediate scrutiny. Because now you're just in time, place, well, at least as long as it's not content-based. So we'll assume it's not content-based and not... So it's viewpoint neutral and content neutral. So if you have a regulation that's content neutral and viewpoint neutral, then typically you're under intermediate scrutiny. Time, place, and manner restrictions. So your go-to examples there are people in the park can give speeches, but they can't use sound amplification equipment. Rationale. There's a school immediately nearby and we don't want the school to be disturbed. No problem. We don't want loud noises after 9 o'clock. Why not? People are asleep. No problem. We don't want people protesting right outside someone's home. Why? Because the home is special. No problem. So if it's the government passing a law that's viewpoint neutral and viewpoint neutral and content neutral, then typically intermediate scrutiny. And typically you're talking about time, place, manner restrictions. These are the times, these are the place, these are the manners. As long as they meet intermediate scrutiny. So it's not rational basis, it's intermediate. So it's not that you can just do it willy-nilly. You have to have a substantial governmental interest, and it has to be narrowly tailored to the problem. It doesn't have to be the least restrictive means like strict scrutiny, but it has to be narrowly tailored. So you're in the middle. So you have not just any interest or just not a legitimate interest, and you don't have a compelling interest, you're in the middle, a substantial interest, and not just anything, any legitimate means, not just the least restrictive means, but narrowly tailored means. You're in the middle. So the government was passing a statute that said we're going to restrict speech that's viewpoint neutral and viewpoint neutral and subject matter neutral, then typically you're in intermediate scrutiny. I'm not sure that applies here or not, and I can't figure it out right away. So this is more of me highlighting the issue than me making a legal determination, because I don't always know the answer to every legal question, because some legal questions don't have answers yet. So I don't know the answer to the question. Here's why I don't know the answer. It's not saying it's impacting a private party, and it's saying that you can have speech that won't bring you liability, but only if it's viewpoint neutral. Is that the same thing? I'm not quite sure if it's the same thing or not. I'm not sure if it's the same thing or different. It might be different, because you'd be essentially saying you can't have a particular viewpoint, but then maybe not. But then here's also where it also gets complicated, because the whole thing is about protecting speech that isn't yours. That's the point of 230. The people aren't liable for speech that isn't theirs. They're just allowing that speech to exist. So it's a bit of a problem also for Twitter, or anyone else for that matter, but we'll use Twitter as an example. It's a bit of a problem for Twitter to say simultaneously, this is not my speech, this is someone else's speech, but also you're infringing my freedom of speech by requiring me to be viewpoint neutral by allowing all this speech that isn't mine in the first place. You see the logical contradiction there? It's like Twitter's argument is you are forcing me to have a particular viewpoint, or not allowing me to have my own viewpoint, which isn't quite the same thing, because Twitter could still have its own Twitter page. So Twitter could still have @Twitter, and they can say anything they want. So it isn't technically restricting their speech. So Twitter can still have @Twitter and say whatever the damn well they please. This is more about other people's speech. So Twitter's argument is you're restricting my viewpoint by not allowing me to have a viewpoint when it comes to other people's speech that's on my platform. But it's other people's speech. It's not their speech. So whose First Amendment right is really being impacted by that? Is it really Twitter's First Amendment interest? Because it wasn't their speech, but they were allowing the speech. So they didn't have to have a platform, but they do have a platform. So they could choose not to have a platform. Twitter could choose not to have a platform. Twitter could just choose to have just @Twitter and nothing else. So Twitter could be just @Twitter and nothing else if they were so inclined. So they could choose not to have a platform, but they do have a platform. And can they have a viewpoint as it relates to the things that they're allowing on a platform when it's not really their speech, but it's their platform and they're allowing it to exist? So can they have a viewpoint in the nature of the platform? That's a really tight question. I don't know the answer to that question, because it's not really clear whose First Amendment rights are being impacted by that. It's not clear whose interest it is, but it's a really complicated legal argument. So to quote Tim Pool, it's complicated, man. It's complicated. I don't know the answer to the question. I don't know if it's intermediate scrutiny or if I don't. So it's either intermediate scrutiny or blatantly unconstitutional. It's one of the two. Probably. It's either intermediate scrutiny or blatantly unconstitutional. I don't know if it's intermediate scrutiny or blatantly unconstitutional. I'm not sure. Because it's a really tight legal issue. Really, really interesting issue. So can Congress say you only get liability if you're viewpoint neutral? Is that itself a viewpoint neutral law? It's gonna be a fight. It's gonna be a fight, man. Oof, that's gonna be a fight. That'd be a fight. I don't know the answer to that question. That'd be one hell of a litigation. I don't know if you can do that or not. It would be epic, I think, because the arguments are pretty good both ways. It's pretty good both ways. So, yeah, the thing that's making it challenging is Twitter's trying as Marty Tube 821 points out, in chat. The problem is that Twitter is kind of trying to have it both ways, and that's a problem for Twitter. They're trying to say they're trying to say the platform is not my speech because it's not my liability, but it is my speech because you're making me have a viewpoint by being viewpoint neutral. So they are trying to have it both ways. It's a logical problem for Twitter, but it's also a problem for the government. I'm not sure who has the better end of it. Twitter's trying to have it both ways, but they might be able to have it both ways. It's tight. It's a tight issue. If Congress does it, it'll be one hell of a litigation. We will definitely follow that every step of the way because that'll be a U.S. Supreme Court case someday, trying to figure all that out. Oof, that'll be tough. And then, of course, at that point, I'll have a much more well-informed legal opinion because at that point, we'll have gone through much more legal analysis and I'll run many more legal briefs. So I'm trying to project all the legal issues that I can see, which of course is not all the issues that exist. I'm only so smart. I'm trying to project all the legal issues I can see and trying to run that through my head and try to figure out, okay, assuming Congress did this, how would that come out and what's the legal analysis, and trying to project that. And I'm like, oh, this is tough. But yeah, other people will comment on it and then I'll be smarter and I'll be able to have a more intelligent opinion. So in 10 years, if Congress passes a statute and all this comes to pass and the regulations come to pass, maybe in 10 years when we do Supreme Court Reacts edition 2030, which hopefully will be a better edition than 2020 in terms of what's going on in the world, we'll be able to see what the heck is going on. So I'll respond to some different comments because I haven't been responding to most of the comments most of the way. That's just because I've been reading the things. So I'll go back and just go back to the top and just I'll go since Willie's are at least. Did they not rule that Trump could not block anyone? That is the decision of the Court of Appeals right now for, I think it's a decision of the Court of Appeals in any way. Yeah, so Twitter can't, or apologize, President Trump can't block anybody. Yes, that's true. But Trump can't block, yeah. Twitter isn't fact checking all this stuff. There's no additional context. Yeah, they are treating it unevenly. These companies are all headquartered in 30 minutes from San Francisco. And it's completely bubbled on reality. Yeah, but it was a different bubble 30 years ago. It's a very weird thing. Free speech is necessary so that free idiots are in full view and called as they should be. Yeah, I think that is one of the values. There's many, many values to free speech. There's many values to free speech. One is so that the sunlight can be the disinfectant for bad ideas rather than it growing in the dark places. That's one. And there's also value to you as an individual because if you say something stupid, then people will correct you and then maybe you'll be less stupid, which is one of the running theories I have for First Amendment. Why is the First Amendment good for me? The First Amendment is good for me because I'll say stuff and then if I'm wrong, people will tell me and then maybe I'll be less stupid. That's a plus. I'd like to not be stupid. So I'm using my freedom of speech to expose my own stupidity in the hope that people will alert me to my stupidity and then I'll be less stupid. I'm exploiting everyone by trying to get smarter. Prager University has big issues with YouTube. Yes, they certainly do. Twitter's driving them into dark corners. Yeah, that's true. That is a big problem. Twitter, by their actions, is forcing people, well, not forcing, but directing people into other places, like 4chan, 8chan, other stuff, and yeah, the darkness is not good. I like Fairness Doctrine to come back. It would be an absolute S show. CNN, CNBC would lose their licenses overnight. Well, for what it's worth, Fairness Doctrine, at least in its original form, only applied to broadcast. So CNN, CNBC were never covered by Fairness Doctrine because it only applied to broadcast mediums for the reason I said. So one of the reasons it went away was because cable was overtaking and there was more options. But yeah. Ooh, $100 super chat. Excellent. I'm going to just go down and do that right away. $100. Thank you very, very, very much. Django Fett, that's very, very nice. As an active military member, what better way to support and defend the Constitution of the United States than to support someone who's educated me in great depth about the very Constitution I've sworn to defend? Excellent. I'm very thankful for your service. I'm thankful for every military member service because you give me the freedom to be an American. And I said this on Memorial Day. Some people have different views about Memorial Day in terms of how you should celebrate it. I think any way to celebrate is valid as long as you're like at least consciously making the effort to remember that you're doing it because of the veterans. So some people will say things like it's not a valid way to celebrate Memorial Day to have barbecues and things like that. At least to me, I think it's valid as long as you're like trying to make an effort to remember the fact that you can have a barbecue is because people fought for it. So I think that's good. But thank you very much. Do you think qualified immunity should be constrained by changing clearly established to reasonably established or substantially established? My best opinion for how qualified immunity should be constrained, my best view on this is that a court should be because right now the courts have the option to do it by Supreme Court language, but I think they should be obligated to do it. So courts can do it now. I just think they should be obligated. So what do I think that they should be obligated to do? I think they should be obligated to say, whether or not it was a constitutional violation, so that at least going forward, it's clearly established. So I don't think they should be able to avoid the issue. Right now, they can avoid the issue, and most courts do. Occasionally, you'll see a court that says, well, going forward, here's what's going to be the rule. Because they have the authority to do that under Supreme Court precedent, but it's an option. I think they should be required to. I think that would be great. And then we could, through development of case law, make it way clearer what is and is not clearly established. So if it were me, Supreme Court Justice, assuming that I wasn't just going to strike down qualified immunity, which is not outside the realm of possibility, but assuming I wasn't going to just strike down qualified immunity, that's what I'd be doing. I'd making what is now optional mandatory. So that's how I'd solve that problem. Or be at least my first impulse to solve the problem. And thank you very much for your super chats and your service. I'll do some super chats going backwards too. $2. Would time, place, and manners include vulgarity? No, vulgarity is not time, place, and manner. That's content-based, because it's based on the words you're saying. So that's content-based restrictions. So strict scrutiny applies. No, and your go-to case on that is Cohen versus California, where a person wore, don't ask me questions about why, but a person wore a leather jacket into a courtroom, which immediately is automatically a no-no. But they weren't there for court. I think they were just there to watch. But they were, either way, don't look like a schlub. Leather jacket is not recommended. But it wasn't that they wore a leather jacket. It was specifically that the leather jacket said in big, bold letters, F the draft. And they got in trouble with contempt of court, and no, not so much. So no, vulgarity is not time, place, and manner. Your go-to case is Cohen versus California. It is legal to wear a leather jacket in a courtroom that says F the draft. I don't necessarily recommend the leather or the F the draft sentiment, but that's what, yeah, you can do that. Also, extremely not recommended if you're going to be a witness or a defendant. So if you're in any way part of the official proceedings and you dress like that, as far as I'm concerned, you should be thrown in jail. Now, that's not legal. I'm just saying that if you dress that way, you are behaving like an idiot. Try to dress up to court. You know, suit and tie would be preferable, but just try to make an effort. How about a dress shirt with a tie and maybe some slacks of some kind? That would be great. Could you not wear sneakers maybe? That would be helpful. Try not to look like an idiot. Put in some effort. Please. I beg you. I've seen people go to court. I mean, even for traffic court. I've seen people go to court for wearing all kinds of stuff. I'd rather you not do all those things. That'd be great. So where was I in terms of trying to do super chat, or in terms of trying to do chats? So C4 Cypher said presumption that the parties to contract would deal with each other honestly, fairly, so as not to destroy the other. Yeah, there is a duty of good faith and fair dealing in most contracts. And it requires people to behave in a way that, you know, they're being honest with each other, essentially, for lack of a better description. So you could also try to import the good faith language from general contract law into this as well. It's a reasonable idea because there's some contract principles here, or at least quasi-contract in terms of it. Because Section 230 itself doesn't have anything to do with contract, but of course, end-user license agreements do. So if not contract, at least quasi-contract. So looking to contract law to define good faith is not a bad idea. It's just the other stuff is so subjective, it's going to be a little bit of a problem. So, yeah, in terms of trying to apply that. The known persona said the best argument against big tech censorship, the fact that their actions become indistinguishable from government action and censorship. Well, yeah, indistinguishable as a matter of practical reality, maybe. Although because the tech companies have gotten so big and because they all seem to do the same thing, which also incidentally is a basis for antitrust. And the YouTube lawyer who disappeared off the face of the earth, and I really wish he would come back because I liked his stuff. He was trying to put together a class action or a complaint or something to make someone do antitrust stuff. I think he was petitioning the FTC. And he disappeared off the face of the earth because it does seem that all the tech companies do seem to act in concert with each other. So there's two potential explanations for that. One of those is legal and one of those is not. The legal explanation for why they all do the same thing is that they are of one mind because they all live in the same area and they all just think the same, which seems kind of plausible. But the time issue is so tight. Like when they ban someone, they all seem to do the same thing. So the legal reason is it's just simultaneous action that is not coordinated. That's legal. What is illegal is coordinated. You can't do that. You can't form an agreement, otherwise known as a trust, to restrain trade. You can't do that. So if all the tech companies have an agreement that they're going to do this, that's the illegal version. So is it legal because they're just all happen to be doing the same thing, or is it illegal because they're doing it by agreement with each other? So yeah, you could get into antitrust if it's illegal because they're all doing it with concert with each other. Big tech has banned and censored speech opposing lockdowns, including those of doctors. Yes, annoyingly. They have collaborated with governments to create apps and ban speech opposing lockdowns, granting them immense wealth. I mean, tech companies can create apps, and there might be a legitimate reason for them, and there's interest in health safety and all kinds of issues that we don't have time to get into. The problem is those who used to stand and speak in the public square are forced by the government instead to stand and speak on the online square, as the physical square has been shut by the government. In these times, that's very, very true, even giving the government even more interest right now. But it would be interesting. It would be interesting as a legal idea for the government attorneys to use this situation where online speech has become the dominant thing to try to create some additional legal rationale going forward. That'd be an interesting thing. If I were a lawyer, I'd be thinking about it and trying to play with it, see if I could make something work. If I were a lawyer for the government. So if I were trying to make this regulation work, I'd be thinking to myself, well, the current situation has created this reality where the public square is closed. So can I use that on an ongoing basis forward to do something here I wouldn't otherwise do because it's become demonstrated? I don't know, but I think about it. I think about it very hard over very long periods of time. See if I can make that work. Politicians at the same time call for the big tech companies to shut down speech opposing lockdowns. The politicians doing that is definitely a problem. And if it was also I raised this point before too, because there was suggestion that in some of the cases where Facebook et al. Were taking down some of these things, they were doing it because the government encouraged them to do it. So depending on exactly what encouraged means, it might be state action. So depending on exactly what the government did or did not do, then maybe Facebook was doing state action when they took those things down. You'd have to show a lot to get there. But when there was some suggestion that the local authorities or even state authorities were making suggestions to Facebook, what exactly does that mean? That might make what Facebook was doing state action. It's possible. You need to show a lot, but at least caught my attention when I saw that in the news. I'm like, that sounds suspiciously like it could be state action. Maybe, yeah, it caught my attention at the time. When are these big tech companies indistinguishable from the government? Then how are they not the government? They're not the government because they don't have the power to arrest, among other things. They don't have the power to put you in jail. They don't have the power to pass statutes. They don't have the ability to impose on you in terms of making you do stuff. So Twitter cannot give me an order to do anything, thank God. The fairness doctrine was not about the government taking over. It's about ensuring there's not partisan BS. Yeah, it was also because of the limited communication channels at the time. I don't want the government to take over either because eventually it'll be the other party in power. Yeah, that's also an interest in this thing and trying to figure out how you write this in such a way that's going to be fair. But it might be because the government can't impose viewpoints, but it might be able to do something that's viewpoint neutral. So it's not clear necessarily the other party could necessarily change that, but they might, depending on how things are written. You're getting into some issues about what the other party might or might not be able to do when they took over. It depends how things are written in statute particularly. If you put the fairness doctrine stuff into the statute, then it can't be changed by regulation. Even Chevron doesn't go that far, thank God. So if you're really, really clear about it, you can't modify that. So you might be able to do it. There's a problem with the Commerce Clause. It's been established that fellow selling as vegetables in highway commerce. Yeah. What could commerce do this day is that would actually be useful? A lot of things commerce could do that would be useful. There's a lot of things Congress could do that would be useful. What they will do, I don't know. I think politicians should be kicked off social media since they can't use it responsibly. No, I disagree with that for exactly the reason that was brought before. I think that the light is better than the darkness. And I think politicians exposing themselves as fools is probably a good thing because the voters can use that information as part of their voting decisions. I'd rather have that information than not when casting my decisions. So I'm not sure kicking them off social media is a good idea. All organizations tend toward bureaucracy and corruption. A little bit, yes, especially as they get bigger. Can an executive order define Twitter as a public square? No, it can't do that much. And also, as I pointed out, executive orders are to the executive. Executive orders by themselves can't impose on private parties. Executive orders only impose on the executive. They're directives from the president to another member of the executive. So an executive order can't, by its own terms, impact Twitter directly. It could order some agency to do something that would impact Twitter, but it can't by its own terms impact Twitter. So no. You left me a message on Amazon pricing for storing data on Discord. Okay, I'll take a look at that. I'm assuming I have to check that right now. I hope your 2020 is the year work get murdered. That'd be nice. Can Congress make it become a publisher when they try to censor non-criminal speech or age restrictions? Well, that's essentially the same question as asking, can they remove the liability shield for those same reasons? Because the liability shield is what's not making them publishers. Because in long ago, in the far, far away before the old decision, they were just republishing. So can Congress make them republishers or remove their immunity when they try to censor non-criminal speech or age restrictions? I mean, you're running into similar issues legally. You're running in the same issues. Like, is that a neutral thing or not a neutral thing? I don't know. We need to hear you say harumph, I say. Harumph, I say. Harumph. You need to set rules, not moving goalposts. Yeah, that's one of the things that, especially by formal rulemaking, that government can do. Because formal rulemaking takes a long time. And so it's a lot more solid than terms of service, which can just change willy-nilly. Regulations, although they can be changed, can't be changed quite that easily. How are big tech not the government when they collab with the government to make COVID tracking up, censor offensive speech? But yeah, we covered that already. Twitter is a Me Too scandal coming. Yeah, that's probably true. The government hires them to make an app that they're government actors insofar as the app, but nothing else. Not necessarily. It depends. It depends a little bit more on what the app is and what it's doing. It's not quite as simple. It's not quite as simple as the government cuts you a check and therefore you're a governmental actor. You need a little bit more. So it depends a little bit more on exactly the nature of the app. So just because the government is paying these people to produce some sort of COVID tracking app, we need to get into a deeper analysis about whether or not might or might not be state action. For example, who's the data being shared with and all kinds of things. So it might be state action, but you need a little bit more. Could Twitter argue them that forcing them to censor speech is analogous to speech? Probably. I mean, if you wrote a law that required people to censor certain kinds of speech in particular, that wasn't of a criminal nature, but just then it's viewpoint-based discrimination, right? So if you said if the government said you must censor speech of a particular kind, then presumably that's viewpoint. But here it's not quite the same thing. They're not saying you must censor speech of a particular viewpoint. They're saying you must allow all viewpoints. And that might be different enough, logically. Not sure yet. Yeah, FedEx is not the government. Yeah. So even if are we not going to talk about Minnesota Riot or what? We can talk about it too. It's just not the topic at the moment. We were talking about this thing, but yeah, we can talk about the Minnesota Riot. I don't approve of it. I think having watched the tape, and I thought Nate Brody made a very good point, and that you might be able to make this murder too. Because to get to murder 2, one of the things that typically gets you there is reckless behavior. And I was like, I don't think it's reckless in my initial analysis. And then I talked to Nate Brody, and he said, well, no, it might be because people were informing him as he was doing it that they should stop doing it. I'm like, oh, okay, that might be enough, particularly in light of his previous training and previous knowledge. So I'm assuming somewhere in the academy he got training about things that would be relevant to this, and then being actively informed as it's happening by people that he should stop doing it, then might create reckless disregard. So you might be able to get to murder rather than just manslaughter. So I thought that was a very interesting idea from Nate Brody. Might work. I think it's probably an overcharge. I think you're probably better with a lesser count, probably manslaughter or something, but at least legally it might work. Thank you again to Django Fret for the thing. Someone contradicted me on the tightness issue. Or at least commented on it. I lost it because it's okay. I don't think KL said, I don't think it's tight as you're saying. Speech on social media is being censored like the Chinese governments. If you mean the Chinese government is the one doing the censoring, that doesn't trigger a First Amendment issue because our First Amendment doesn't extend to them. So if you mean the Chinese government themselves is doing the censoring, then that's outside of anything. If you mean that the tech companies are censoring as though they were like China, so they're censoring in the same way that China is censoring, then yes, but we run into problems because it's private action, not governmental action. And so we have to do different kinds of analysis to get to where we want to be. And the viewpoint neutral thing is a really problematic issue. So trying to figure out exactly how that interacts is not clear to me. This is dangerous because most speech takes place on those platforms. I'm not sure whether that's true or not, whether or not most speech takes place on the platforms. If I had to guess, I don't know. I don't know whether or not most speech takes place on there or not. It's an interesting question. But a lot certainly does. Yeah. Should Twitter be forced to let you say something that goes against their interest? Well, let's say, yeah, that's a good point. So Viewpoint would include such things as Viewpoint of Twitter blows, but it's not their speech. So the First Amendment analysis is tricky because it's not their speech. They're getting immunity because it's not their speech. Should they be forced to allow it on their platform? It's tight. It's a tough question. How are Twitter and government not an online company city when they and the governments have become indistinguishable from governmental action? People tried the online. It's company town, by the way, is the phrase, not company city, but it's just a aside. The phrase is company town. But anyways, people tried the online thing with company town. They tried it with AOL. They tried it with AOL back when AOL was the internet. We remember when AOL was the internet. I mean, AOL at the time was bigger than these tech companies were. There were a couple people competing with AOL, but not really to speak of. So there was a time and place when AOL was pretty much the internet. And so someone tried the thing with AOL, and it didn't work with AOL. So if it didn't work with AOL, it's not going to work with Facebook. So there's case law on that. So they're not a company town. The thing with company towns is they're acting as a government because of all the things they're doing. So let me tell you what a company town is, because you may not know this expression. So we can talk a little bit about what that is and what it isn't. All right. So typically private actors, as we've discussed, are not bound by the Constitution. Excuse me. One of those exceptions where private entities are bound by the Constitution is in the case of a company town. So what's a company town? Well, they were typically, although not exclusively, they were typically towns that were set up in the middle of nowhere for the purposes of resource extraction, lumber, mining, something like that. So someone found a deposit of whatever in the middle of nowhere, and they need workers to go there and work. So the company would build a town, basically. They would build a town, and they would build houses, and there'd be churches and post offices and all that thing. And sometimes they would have their own company money, although that's not necessarily required. And they would impose rules on people who lived in the town because it was all owned by the company. And the case law basically says, in short, that there's a point somewhere along the line where you adopt so many traditional government functions that you're bound by that. So at some point along the line, it's not, at some point along the line, you control the roads, you control the schools, you control the post office, you control the police, you control the fire station. Somewhere along the line, you control the money. Somewhere along the line, you became so all encompassing that you are just adopting all the roles of a government. And so we're going to hold the Constitution to you. So those were company towns. Why aren't the online services company towns? Well, one, because of the case I just cited, and two, because they're quite all-encompassing in that way. You don't have to be on Twitter. No one is obligated to be, and I don't. The only reason I use Twitter at all is I have an automated script that sends out notice of these videos so that people will see them, so that people have an alternative channel. I don't really like Twitter, so I don't use Twitter except for that limited purpose. So, you don't have to use Twitter. I don't. It might, and you might be well advised not to, because Twitter is a very sad place, but that's the reason why. Yeah, so the company town thing, there was a case against OL. Someone tried that trick. Yeah, please just wear appropriate courtroom attire. Just try. You don't have to be able to afford fancy clothes. I mean, just try, and you can go to a thrift store. I mean, it doesn't have to be new. It just has to, just a basic dress shirt and some like khakis and a tie would be fine. You go to a thrift store and get some stuff cheap, or go to Walmart and get some stuff cheap. Again, I'm not asking you to spend lots of money, or Target or somewhere else. I'm not asking you to spend lots of money. I'm just asking you to please not look like a complete slob. It would be great. You don't have to spend a lot of money to do this, especially if you go to a thrift store. So if you're really poor, if you can, please spend a couple bucks and go to a thrift store and just find a decent pair of pants and a decent shirt and a decent tie. Look present and wash it. Look presentable. Please, it's in your legal interest. You're either testifying or you're a defendant. We'd like this to go well. We want to make an impression, so it's important. People will judge you, at least in part, by how you dress. Are you saying I should retain a less expensive lawyer and invest in a suit? No, not necessarily. I'm saying that you should spend $20 to put together an outfit at your local thrift store is what I'm saying. You could argue the shutdown is unconstitutional because it shut down the public square, but it doesn't shut them down and turning something else. The constitutional analysis for shutting down that stuff down is strict scrutiny. We've discussed that before. Yeah, lawyer Lesser, I missed that guy. Uncivil law. It's not just the tech companies. The finance and credit card companies act in concert well. They very well might. And we've seen some evidence of that. There was one tweet, somewhat infamously one time, where Twitter said, "Oh, this is because MasterCard," which sounds suspiciously like it might be Coronation. So there might be an antitrust issue there. People have had accounts closed as their result of Twitter. Yeah, but you have to actually have coordination. That's the thing. So if the bank is doing it because you were deplatformed by Twitter, if they're doing it independently, it's legal. A bank is a private entity. They can choose to do business with whom they want or not. So if they say, well, you were deplatformed, therefore I'm going to deplatform you, if it's independent judgment, they can do that. It's only illegal if it's coordinated. So you have to show the coordination. That's because you need an agreement, a trust. That's what antitrust is. Trust is an agreement, right? Or, so you need an agreement to restrain trade. So you need the agreement between the two parties, between the two businesses. And that's not, the only definition of antitrust. It's a prerequisite. So some things are still legal even past that. Antitrust law is more complicated than that, obviously. But, restraint on trade is bad. Having to wear a suit is just another way the law discriminates against the average Joe. It's not even the law that's discriminating. It's the jury of your peers. If you're a criminal defendant in a criminal case, a jury of your peers is going to be looking at you. And people discriminate against people all the time. So do you want to make a good impression on your fellow people or not? It's like, if you're not even trying to take your own case seriously, why should the jury? People judge each other. They are literally impaneled to judge you. That is literally their job. Who are you to judge me? Oh, that's right, you're the jury. They're literally impaneled in part to judge you. And the way you dress has a material effect on that. And again, you don't have to spend a ton of money here. You can do this for $20. You can go to a thrift store and you get some stuff. You can find some cheap things. So you don't have to put in a ton of effort. But, just don't wear like sweats and t-shirts, and don't wear a "I wish I was smoking a blunt" shirt and stuff like that in the court. That'd be great. Just try a little bit. How are you doing, A. Hedinger? Nice to have you. If Facebook did state action, who could get in trouble? Facebook or the state? Facebook would get in trouble. If Facebook did state action, you could sue Facebook under 42 U.S.C. 1983. You could sue them for deprivation of civil rights by a state actor. So yeah, if Facebook did it because the government whispered in their ear the right way, then they're a state actor, and you can sue them for violation because they're a state actor. So yeah, you could sue Facebook under 42 U.S.C. 1983. Normally you can't do that, but if you can, if they're a state actor, so you need a little bit more, but yeah, you can do it. They'd be, and also presumably the government would also be liable because they directed it as under Monell. So yeah, you could sue both the state and Facebook under 42 U.S.C. 1983. Fun times. Yeah, watching Kurt think is always fun. Yeah, because you can see the wheels pin in my head. Silent Sunlight is the disinfectant. I agree with that. How do you do that thing where you see my name in orange like I've seen? Oh, that's Super Chat. I believe the orange is $20. So yeah, the different levels of Super Chat have different colors. So you could see this one in red is $100 because it's red. You've seen different colors. Different monetary amounts have different colors. I think orange is $20. So if you want your comment to be highlighted in orange, then what you do is you go to the bottom of your screen, and there should be a little dollar icon somewhere on your screen. And if you press that little dollar icon, you can choose to donate an amount of money, and it will show you what color it would use. And then your comment will pop up with the right color, and I will thank you and be happy. I personally would prefer red to orange, but I will happily take orange. And I owe my soul to AOL. Owe my soul to the company store. Yeah, a little bit, yeah. Allowing all viewpoints also, in essence, mandates forced association. Maybe. Yeah, you have similar problems there for freedom of association. You might have problems there too. But it's, yeah, good point. Freedom of association is a point too. So yeah, you might have a problem there. You might have a problem there. Yeah, that's a problem. Greg in Houston said, "No, that's not it." No, what's not it? Oh, the orange. What's not it? Oh, I'm at the bottom now. Still no digital money. Yeah, I'm at the bottom. He was asking a boomer question about tagging another person. Oh, if you want your comment to be, if you want something to be in orange, the only way it would show up in orange to you is if someone is tagging you. So when someone tags you, it shows up in orange so you can see it. So the only way it would show up in orange in the middle of your sentence like that is if you are tagged. So someone puts that description. If you want someone else to see orange, then you would put their name in the @ symbol. So you do @ with their name, and then it will show orange to them, but not to you. So it's a way for you to see in chat when someone's talking to you. Do I like what on the bottom? I'm not sure what I said there as the antecedent. Yeah. The orange jumpsuit is negative from the start. Yes, it's considered prejudicial. That's why a defendant in a criminal trial is almost never, especially when there's a jury present, is almost never in a jumpsuit. Why have you ever wondered why a criminal defendant in a trial is not in a jumpsuit or not in handcuffs while the trial is? The reason is because it's prejudicial. So yeah, you don't put the defendant in hand unless they're being unruly. Then you can put them in handcuffs. So they can only put them in handcuffs if it's necessary because they're being so unruly. But yeah, you don't put them in handcuffs and you don't put them in jump shoot because it's prejudicial. We already have enough things going against the defendant. They're already sitting on that table over there. So we don't want to remove as much prejudice as possible, as opposed to our brethren in the UK where they have the dock. Yeah, the dock. They have a special area for you to stand in that has bars and everything. That's not prejudicial. Putting you in an area with bars, that's not prejudicial. Way to go, UK. We don't have the dock. We have you sitting at a table like a normal person. The known persona says in some states the government issued by decree the effect of wearing a mask under threat of jail. However, those same states have anti-masking laws. You'd be breaking. What is the law? Yeah, very fair point. You can't have two things at the same time, right? So you would be reading in the suspension of the other law because the executive can waive other laws. It would be helpful if they mentioned it in the statute. But yeah, a lot of states, particularly southern states, have anti-masking laws because of this plan. So yeah, good times. Why do I sometimes see people in an orange V-neck looking jail clothes during the middle of a jury trial? I mean, no, you wouldn't see that in a jury trial. You might see that after the person has been convicted. So if the person has been convicted and is coming for sentencing, you might see it because they've already been convicted. So you might see it in a sentencing, but you wouldn't see it in an ongoing jury trial. And you wouldn't certainly see it on an appeal like that. So cool. All right, thank you. So thank you again so much for all the super chats. It was super thankful. I appreciate it a lot. Thank you so much for the $100 super chat in particular. It really helps me grow. It really makes a huge difference. I'm currently trying to save up for a better camera. I'm looking at the Sony Alpha series. Not sure exactly which one. Maybe the 6000 or 6100. So need about $500 or $600, especially by the time I put a lens on. But then it will look great. So, that'll be super appreciated. So thank you for all the super chats. If you have not done also already, and you can also become a member. So thank you to the 2 new members who joined. If you've not already become a member, there should be a join button somewhere on your screen. If you press the join button for 99 cents, your name can become green. And then you will be cool. And I will like you more. And please like the stream. There's a new Sony vlogging camera. Interesting. Leonard, let's talk about that when we go back to Discord. I'm interested to learn about that. Yeah. I'm not worried about the SD card being filled because I'm just using it for streaming, but yeah. Sony ZV-1. I'll take a look at it. Cool. Thank you very, very much. Very cool. Thank you for helping us to understand the legal issues. Something just happened, yeah. And I hopefully exposed the relevant legal issues and relevant things. So there's some stuff here that's good, some stuff here that's possible. I'm not sure how the FCC is going to do anything. That'll be hilarious. The FTC might be able to do something, and we'll see what happens next. Yeah. Get a Blackmagic 6K? No, that's okay. The Sony vlogging camera $799 though. I don't know about that, man. I don't know about that. That's a little pricey. The 5100 is like $400. It's like $430 with a lens, and then like the other one's like $480 with a lens. $799 is pretty, but Sony cameras are pretty nice. Anyways, I'm gonna peace out later, guys. Love you all. Later. Bye.